Good evening to everyone present here. I, Avneet Kaur, member of Sambhav Initiative and moderator for today's event. On behalf of organizing committee, I extend a warm welcome to our esteemed dignitary, Ms. Surabhi Chopra ma'am, and to all the participants in this 2 weeks national online capacity building program on family laws, court practice, procedure, and drafting, jointly organized by Sambhav Initiative, working towards alternative dispute resolution, free legal aid, and building legal literacy among different groups of society in collaboration with Pro Bono India, which is working towards legal aid and legal literacy. Where today's session is all about introduction to family law and family court procedures. It is my privilege to introduce our esteemed dignitary, Ms. Surabhi Chopra ma'am. Ma'am is the founder and managing partner of Legis Chamber, a distinguished law firm renowned for its expertise in civil, criminal, and international immigration law. A graduate of Delhi Indraprastha University with a Master of Laws from London, ma'am brings together a strong academic foundation with extensive practical experience in the legal field. Originally from Bangalore, Ma'am's journey to establishing and leading an internationally recognized law firm reflects her resilience, strategic vision, and unwavering commitment to justice. Under her leadership, Legis Chamber has grown into a trusted provider of comprehensive litigation and global legal services. Known for her innovative approach and dedication to addressing systemic issues with the legal system, Advocate Surabhi Chopra ma'am has earned widespread respect and recognition within the legal community. Her work continues to inspire a new generation of legal professionals, particularly women, to pursue their careers with integrity, determination, and purpose. We are deeply honored to have you with us today, ma'am. Over to you, ma'am.
Good evening, everyone. As you have given me a very long introduction, thank you so much for the warm welcome. And I am here to guide today and discuss and tell you about family laws and the court and the procedure and the acts which is followed. Though I see that from about a few minutes and a while, it's been over 45-50 minutes that you have all been listening about family law and court and procedure. So it has quite been a time period to discuss only about family law. So, but however, I will not want to go again into that, which you have already heard from the respected and my seniors and from the inauguration session, which has been taken by the justice. So, we will start with many aspects. I will always want to have a very interactive session. I believe by the end of the session, maybe 5-7 minutes, we can have some sort of a question answer round. And if you have any questions from the inauguration session or any other question which you have had in the previous two sessions, I would love to answer even that. So in the last 5-7 minutes, I believe we can have that. Yes. The organizers can say this. Yeah, we can have about
Yes,
five
ma'am. Yes,
minutes.
ma'am.
We can have an interactive session.
Yes,
Otherwise,
ma'am.
what's the point of having a session where we don't have any discussion of what kind of questions and queries you have? And also, if you could just tell me what sort of participants do we have here? Are there more students or we have more lawyers in this session?
Ma'am, there are students as well as professionals and advocates as well, ma'am.
I see.
Yes.
Sure. Thank you. So, as we know that today's session is about family law and the court and the procedure. So, I believe court and procedure, if you talk about, it is all about the different laws and different aspects and different kind of cases we are filing in court. So, primarily the procedure and the kind of pattern which is being followed for the e-filing, it is almost similar in all the cases these days. So, if we talk about Supreme Court, if we talk about High Court, if we talk about district courts, most of these states carry the same procedure of e-filing. So I'm starting from the end of the topic rather than to start from the beginning. As in the end, I know that we are covering the portions of e-filing and the online filing and the procedure for that. So I'm talking about that, which is online filing is quite simple and it is quite easy when we say about the digitalization and the case management system dashboard and the e-court filing and the virtual hearing system we have. Post COVID, we have had this era of virtual hearing. So as a solicitor, I practice in England. So there we have all these procedures of e-filing. We had the procedures of virtual hearing. We do hearings by telephone also there. We do phone call hearings whenever there is an urgency in any matter. if there is any sort of situation where we need to take some urgent orders with the court. So we have various forms and methods. Though in India, I don't know when we will have such kind of time that we can have telephone hearings and we can use more of the digital methods to access the justice to all, which can also ease the process. For example, we use fax a lot in England, but we talk about India, we are very far and we are very distant away to use fax, or we do telephone hearings and all of that. But COVID was a very difficult phase, very unfortunate for the whole world. But with that, I'm very glad that India has progressed towards the technology and we have got the system of virtual hearing. And today, at this point of time in Delhi and Maharashtra, also in Bangalore, we have an e-court system wherein we are doing hearings on virtual hearing basis. Also, we are doing the digital court. In Delhi, we have assigned digital courts wherein all the matters are taken digitally only, specifically for 138 matters, where the courts are digital. But for other laws, if we talk about family courts, if we talk about other criminal procedure courts, session courts, we don't have any such court which is a digital court because practically it's very difficult. So, but maybe with time, we can also enter into that phase and that era where things can be eased. So, as today in 2025, I talk about the online pattern, e-filing, case management system, and dashboard. Everything has drastically changed in last 3 4 years. The whole pattern, the whole management system of the cases is changed. We do PDF filing first. So previously, if you talk about a comparison, maybe with that we can understand, and my fellow colleagues and advocates who are also part here, they will be able to correlate that how is to be in 2013, 14, 15, 16, before COVID, we may say that way, that the matters used to be in a hard copy form. We used to prepare the file and just submit the file in the court in a hard copy form and the matter would be taken up. But now, if you talk about today, today the procedure is changed, completely changed. It is stark opposite. With that, we have so many employment opportunities which has come up for the IT sector only. When we have to do PDF files, we do the scanning. We have to go to the portal. You need to have your own login IDs. Therefore, in your login IDs, you will do complete PDF filing of your case, and then you will be marked your diary number, and your e-filing number will come with that. And even if you have to file a minor application now in the court, it will go through the process of e-filing only. So once you do the e-filing, after that your case will be there or your application will be there. Further to that, your mattress hard copy will go to the court. So the system has been reversed. It has been changed. For the graduates, for the students who are going to pass out, now when they will enter into the legal fraternity, it is very easy for them to understand because now the method is not that which we used to have at that time. So there's no complication for them because for them it is a straightforward method that this is the only procedure which is carried out of e-filing. But previously for my colleagues, for the people who are registered in 2000, sometime in 2000s or in 15 or 14, for them it is a transition phase which the courts are going through. Even for the judges, it is a transition phase which they are going through to understand the whole system and the mechanism which has been created for the online filing, e-filing, and then the way the objections are marked, specifically in High Court and Supreme Court. Even in district courts in many states, they mark objections when you file. Those are called the legal objections. So the legal objections, once they come up, you have to remove those objections. Once the objections are removed, it will then come up for the listing of the cases. So unless and until the objections are not removed, it will not come up. So what you do is after you do the e-filing, we wait for the objections from the court side if there are any objections in the cases. In High Court and Supreme Court, the objections are too many. If I'll give you an example about objections, the objections can be any such thing which can be the margin, the page size, or maybe the translation copies. If you are in Delhi, then if you're practicing here, then you have to give a translated copy also for your case. It has to be all in English. And if you have any document which is coming from any other language, Hindi or Gujarati or Marathi, it will be covered under all the translation copies and certified copies of those particular language or particular orders or whatever you file along with your annexures. So annexures has to be in English in Delhi. So these are all little examples I'm just trying to give you is that when you do e-filing, after that legal objections will come. After your legal objections are removed, your cases will be listed before the honorable court or before the district court, wherever your cases are particularly there. So this is just a glimpse of online filing and the world of digitization, where how the e-filing portals will work after that. So what I do in my office is that, because since we get objections and since we do so many filings, what I do always is that in our office we place a list of objections and you paste it in front of your eyes. With that, it will ease your process so much so that you will know that these are the objections which we should not do. If we will do that, it is going to be a sheer wastage of your time and energy. So that is the reason I say is that if you can always make a list of objections, which is the common objections which you will face it all the time, and you don't forget it. Let's say if there are 30 40 kind of objections which you can place it in front of your eyes and you put it over there, and when you're preparing your file, then you can just have your own checklist that this should not come, because in high court and supreme court it can take sometimes forever to get your case listed before the court and remove the objections there. So this is one thing. And that is how the case management system and the whole dashboard is working towards it, right? Then we have the e-court filing and virtual hearing. Once your case has been filed, once the objections are removed, after that we have the e-court filing and virtual hearing. I think if you are looking for the slide, it is the slide number 11 where I'm talking about. I've started from the filing system, which is slide number 11, where I talk about it. So you can have an idea about online filing and e-court. Because when we talk about cases, I think first you have to understand how you will file the court case, how you will enter into the court. So this is what I was trying to mention to you. First, you go with your online filing, then the digitization is the kind of name. Then we have the case management system and the dashboard, which is there where you maintain the entire case record. There is an e-docket which is created. Then you get receive emails. These days you receive SMSs also from the court, especially in High Court and Supreme Court. Any matter which is listed on the next day, once your case is through with filing, with objections being removed, and if it has come up for the listing, for the hearing of the court case, you will get a SMS, you will get an email also for that. After that, we come for the e-court and virtual hearings. That is the last step. Once you are through with this two, you will get a court hearing, which you can do it online also, which is a virtual hearing. So let's say somebody is sitting in Maharashtra and you have got your case registration done, your filing is done. You don't really have to come down to Delhi. You can do your hearings from wherever you are based. And in Delhi specifically, these systems are working very well. Sometimes they can be a technical glitch. So you should always have somebody as a standby person. This is from my own personal experience. I'm saying that it is better to have some clerk or somebody as a standby person there in case the court's technical system is there, or maybe the internet is not working well that day, or something like just like what I have gone through right now. You have seen that the video was not working. I switched to another method and now it's working. Similarly, same things also happen in court, that one thing might not be working or some other thing is not working, because even they are going through this phase. We are trying to have a setup which is brand new or which is only a few years old. So that is how you can get through this process. And then your matters will be listed virtually in the court. And also, parallelly, I'll mention to you that mediations also happen. When the mediations happen in the Samadhan or in the district court level, so you can also do mediation online. You don't really have to come from one country to Delhi or from any other state and come down to Delhi or to Mumbai. You can make an application before the mediation center also that we need to do a virtual mediation in this matter. By moving an application, you will get a link. And with that link, once it is there with you, you can have a mediation which can be online. But for that, you will always have to remember that it has to be done by the form of an application to be moved. And maybe in some other respective states, the procedure is slightly different, which can be looked upon. Then we talk about the, now we can go in the beginning, that where the family court system had started, which is the slide number 2, I believe. Yes, that's right. So I will not really barge into again, because this is the history of the genesis of the Family Court Act of 1984, why it was started. I believe the Honorable Justice has gone in detail with his explanation and his guidance on Family Court Act 1984. But however, just to give you an idea that why this act was enacted, in 1984. Why? There was a need which was there that the law should come at its place. And why was the purpose felt so? And if we talk even now, is that purpose really fulfilled? So, first was that we need such an act, and then the practical applicability of the act when we talk about in 2025. The act was initiated because of the changing environment, changing phase, changing transitions happening in India where there were so many family disputes. If we go behind to that, there were not many. And that time we had the procedure of panchayat. We had people sitting in a common area, or maybe we talk about the temples or maybe religious groups which are there in different parts in rural areas and village areas. They used to settle the family issues and family dispute amongst themselves. So these issues were not in such limelight when we talk about these days. If you see today, if two people are going to have fight, they will straight away go to the court because of the system which has come to its place. People don't really think or are dependent on anybody these days, and they're so empowered by such laws which we have in India that they don't have to think even once that they need to take some guidance or advice that if they want to file a divorce case in court. They just know it by their own education, by their awareness that we can go to the court, हम डिवोर्स ले सकते हैं या हम तलाक ले सकते हैं. दिस इज व्हाट वी से इन रूरल एरियाज. पीपल से हम कोर्ट में जाएंगे और हम तलाक लेंगे. So because of the system which has been created. But if we talk about before 1984 era, that time we did not have anything which was at its place. If somebody is a sufferer in a marriage, be it if it's the husband, if it's the wife who is suffering, or the kids who are suffering, there was nothing much for them at its place that they can take any action. So therefore, if you see in pointers we have mentioned, you can go through what it has been written there. I will not read out. And in in crux we can see when there was a report which was there, which was the 59th report in 1974, wherein the recommendation was placed that for the family dispute matters we should have law at its place. And with changing time, with changing eras, we keep on having amendments. Though in India, if we compare to other countries, we are pretty slow. There is nothing in in there's nothing shy to say in that fact that how quickly are we reforming. In India, the laws are not reformed so quickly. In India, the law reformation is always not so intact that we say that the law which has been made by the legislative body or which has been passed by any of the organizations, it is intact. There are many loopholes and they take a lot of time again to amendment and do the changes. So similarly, in 1984, the laws were passed, and the family law branch of dealing into the legal relationship within the families and marriage and divorce and maintenance for the acts of guardianship and adoption, custody, inheritance, everything came at its place. Then the next slide we move to, which is the slide number 3. We talk about the key objectives of the Family Court Act. What are the key objectives of the Family Court Act? Is to cost effectively readdress the issues which is happening between a marriage or the children's or for the family welfare, whatever is it. These days we have the very famous case of Karishma Kapoor, which is there, right? That is the classic case of family court. I see that maybe after a couple of years or maybe a few more years, they sort out the matter. This is going to be one of the epic cases for family court acts, wherein we see everything which is there. Business is there, property is there, children are there, husband, wife are there. So that is one of the most famous thing. If you are all following up the Karishma Kapoor matter, you will see that it is a classic case which has everything. You have all the spices of law, you have all the acts, you have all the different kind of issues, which is in such a pep manner. So that is why family court plays such an important role. With one family court case, you have multiple laws which get involved. You have criminal law involved with it. You have the child custody matters involved with it. You will have the base case, which is a divorce case, domestic violence case, which will all come in to its place. I was dealing with one of the cases of a captain. He's into merchant navy, and quite a case it was, and very famous and popular case in Delhi, which I've got solved. And if you will just see, with one family dispute, they had 16 cross cases amongst each other. They had property also, custody also, family also, criminal cases also pending amongst them. So only one bracket is family court. Family court, then you have endless disputes happening with all laws. So someone might say that family court is very easy. It is a cakewalk kind of a law, and people or advocates who are dealing into family court matters, it is quite a cakewalk. It is not literally, it is up to an advocate how they're going to deal with it. Only from one aspect of law, they might have many other issues coming across, and it will all intervene into it. So again, coming back to the point, is the key objective of Family Court Act. Yeah, Family Court Act was basically, obviously, with the family only word we understand, it is for disputes which is coming between the marriage, coming between the children, or for the family welfare. And once you can identify, as your law students, you will have to identify, you will take your client briefing and you will understand that this is a Family Court Act. Then you will jot down what laws will come into its place. As I said, it is going to fall with criminal also, maybe with defamation also, maybe with inheritance also, maybe with child custody also, what all it will be included into it. Further to that, what you will see is the jurisdiction. Where will the case really go through? Right? I will skip the slide number 4, which is a basic slide which talks about the key provisions of Family Court Act. You can read out. It talks about the basic provisions, which is the establishment, which is a jurisdiction, which we will talk about the jurisdiction, because that is a very important point. I will give you a reference of one of my own cases. Then you will talk about the duty of the family court to make attempts for the settlement, which they do. In any family court in India, they will do first attempt is to settle out the matter. And for settlement these days, we have many forms, many methods, which is a pre-litigation, which we call in short is a pre-lit, happens in Delhi High Court. We have Samadhan, we have mediation centers in all district courts. We do settlements on that basis. And I always suggest in family court matters, it is very good to settle out the cases. You can do your work and you can settle out the cases. Maybe if somebody is an advocate, they can take their share in the matter and further settle the matter, because ultimately nothing will happen. Whatever kind of a biggest of the biggest matter is, nothing will happen, is only a settlement. So I say that these days, whoever are students in this session, I request and urge them that you should train yourself how to listen out to parties, how to understand the dispute, and how to settle the matter in the very beginning and initial stage of a case which has been assigned to you, or maybe the case which you have got as an opportunity. I always suggest that in the first meeting only, try to understand what does your client want, what does the opposite party want, and how the matter can be settled. So be it you might have to fight the matter, and be it there might be many cases, leaving some of the cases which is going to go on merit. We don't talk about those cases जहाँ पे इंसाफ बहुत ज़्यादा चाहिए. Depends on the kind of case it is. But generally, if I talk, 60 to 70% cases matters get settled only, ultimately, because these are disputes which is coming out of family, and sometimes those dispute will really not make any sense after 3-4 years की किसी ने मुझे क्या बोल दिया था और किसने मुझे क्या कह दिया था. Whoever did whatsoever will not really matter. And that is a time lawyer plays a very important role to see if the matter can be settled. So which is what is coming in what? Section 9. That is what court tried to do, is to family court makes the attempts for settlement of the matter. After that, now we all know that BNS is there, and the laws have taken amendment, laws have been reformed through BNS Act. So BNS Act completely talks about many aspects and many other changes. That is something which can be, I think, covered under some other section which you will have only for BNS. Then the other provisions which are there for assistance and medical, that is section 11, 12, and 13. We all know that the mutual divorce goes under the common settlements, mutual divorce is there, custody is there. These are different laws. Then the next slide is an important slide, is of the jurisdiction. Jurisdiction of the family code. So to understand, where with next slide, please. So the jurisdiction part. So what we say about the jurisdiction is important to understand हम case कहाँ पे डालेंगे. Where should the matter really go? So how you will see that is from the dispute. The marriage dispute, where is it? So basically, if I talk about the jurisdiction, is three most important pointers is that where is the matrimonial house, where is the parental house, and then where was the marriage which was taking place. Three points are the most important points where you will study in law, that is law. Wherever the marriage took place, the matrimonial house and the parental house, from that you make out the jurisdiction. That is one thing which we all know, which is written in the law, that is how you will make the jurisdiction. But then there has been a lot of reformation, there has been a lot of judgments. And if somebody says, I got married in Gwalior, but I resided actually in Jammu Kashmir, I got married in Gwalior. And then further, after my marriage, I shifted straight away to Mumbai to a rented accommodation of my husband. And after the dispute, I actually shifted to Kerala. I got a job maybe in Kerala or in somewhere in South. So somebody might ask, where will we file the court case? Should I go to Kerala? Should I go to Mumbai? Should I go to Jammu and Kashmir? Or should I really go to Gwalior? I have so many jurisdictions to file my cases. So the answer is that's right. Somebody can go to the matrimonial house, they can file a case there. Somebody can go and file a case wherever they have a parental house or the matrimonial house, which is correct. But on the top, on the primary, there are many judgments, and in my own cases, sometimes where there are multiple jurisdictions which are there, and a person really choose to file the case somewhere, let's say it is distant and far away place to Gwalior, but actually the person is residing in Kerala and the husband is residing in some other place, and the girl decided to file the case somewhere on the top. So then when we go to Supreme Court, how do we change the jurisdiction? It is always through a transfer petition. So jurisdiction, law is there. You know that we will file the cases here and there. But then if you have any issue in the jurisdiction, in case if there are multiple jurisdiction and if you feel that the jurisdiction is not justified, then what you do is you will go to Supreme Court, you will file a transfer petition by ascertaining and explaining it to the court that where the matter should really go to. And mostly, I'm saying in one of the matters recently, I got a great order wherein the girl was working in Gurgaon and the matter was filed in Jaipur, and she was staying in Gurgaon for many, many years. And the husband was working in the defense forces and he was serving wherever he was serving, but the matter was none of the places, but was rather filed in Jaipur on the basis of her own home. Further to that, we filed a transfer petition in Supreme Court, explained the entire hierarchy of the jurisdiction, what the girl has been doing, and how she has been hopping from one place to another. Ultimately, we got the great order from the Honorable Court, and all the matters were moved to Gurgaon. Because she was since residing there also, Supreme Court also says, which is the last residing address of the girl, can also have the jurisdiction of filing the cases. Since she is residing there for many years and she is working there, despite the fact that the matrimonial house is not there, the parental house is not there, and the place of marriage is also not there, still the matters were sent to Gurgaon District Court. So we always see on the prima facie, we see where the jurisdiction falls, then we will see on the basis of the merit of the case. And if you have a merit in your case, I always say never lose your heart on it, never bow down, always go fight till the end to get your order and represent it well, explain it well to the court, whatever it is, you will get a very good outcome. Then the jurisdiction we see, and so this was about one thing. Similarly, in domestic violence case, as I've quickly mentioned to you, domestic violence cases, wherever the girl is having its last address, she can file it there. And for the boys' side, they can file the case as per their parental address, matrimonial house, or as per the fact of the part that wherever he is residing as well. Then Guardianship and Adoption Act, again similarly same part is followed. For domestic violence, child custody, for the Guardianship and Adoption Act, same method is followed for jurisdiction. In fact, perhaps in other matters also, similarly, we see on the basis of this only, whatever the address is there. Some of the civil disputes, if I will differentiate you that the fact that the civil disputes, they will come up with the address of the defendant wherever the defendant is residing. There, there the matters will go. So filing procedure, I've explained to you that filing procedure in family court is obviously the next slide, please. Yes. So quickly, in pointers, we have mentioned that first you will see the jurisdiction, then you will draft the petition and suit, then the e-filing part, which we have covered is how you e-file, and you see the court fees if it is there at all. Removing of any objections in e-filing, which is a very important part. As I said, for a quick idea in your cases, you should always have a checklist for your own self, a checklist which is made by you for your own convenience. Then we have the hearing, which you will get, which you can do it by virtual method also, or you can personally also go to the court. Service and the notice to respondent obviously is after the first hearing. First hearing, which is the first hearing of your case, which is marked to you. And once you present your matter in the court and court accepts your case, the notice will be issued to the opposite party for their appearance and filing of their replies or counter statement, whatever it is. And further, the trial will start. This is the very initial stage and basic of for all the matters. All the matters will follow the same sort of a filing procedure, be it its family code or be it any other code, because the world of digitization is same only, whatever matter it is. In fact, even if you want to file an application these days, and if you want to file an urgent application in any of the matter, you will have to file this, you will have to go through the same procedure for filing it, getting it listed before the court, and then you will get it marked. Then the trial will start. Once the trial starts, be it its family court or any other civil matter, you will have to first, next slide please. I'm talking about the trial now. Once the trial will start in the matter, first of all, very first thing you will have to do in the court is to get your matter accepted. You will discuss the jurisdiction, how you made the jurisdiction in this case. Once the court is satisfied with the jurisdiction, the method you have made it, the kind of description or the explanation whatsoever you have given in your matter, how your case falls here, you can go ahead with that. I'll give you a very quick example. I'll take half a second on that. That how in one of our matter, wherein on the wedding card, the one of the venue was different, and one of the function was different in the venue card only because in the same day they had two marriages. So two marriages, one marriage was done in one venue and one marriage was done in another venue, and the place of residence was America, and the matrimonial house is far away, distant, and the parental house is also in another jurisdiction. Aadhaar card had different address. So we were obviously we followed just what was written in the wedding card, but the wedding card again had two addresses. So this was a very good question which came up before the honorable court also, that on what basis are we making jurisdiction, and court was not satisfied that we made the jurisdiction on the basis of the wedding card or the wedding venue. Perhaps we should have gone here and there. And the residents, both of them are resident of America, and they were not satisfied that why we have made the jurisdiction here. So these are some questions when we go, I mean, not on the staple kind of matters which we in routine we see. And then there are complex issues which comes even for jurisdiction. Then you will draft your suit, you will draft your petition, you will do the e-filing which we have discussed, and then the first hearing of the court. Once the first hearing of the court is there, you will explain the jurisdiction part, your matter, what is the merit of your case. After that, court will naturally, once the court is convinced, they will issue notice to the respondent. You will be given an order for PFRC. After that, you will file the trial will be followed with that, which is the next slide. If you can go to the next slide, please. Yes. Then after that, in between, so in if you talk about mediation or settlement in family matters, which is what we see in these days in all the matters, mediation settlement can happen at any stage. Even before, we can do a pre-lit. If it is between, we can opt for a mediation in the court. In High Court, we call it as Samadhan. You can get your matter referred to the mediation, be it if it's the last stage of the case also. You can always do that. Or outside court also settlement can happen. That also is acceptable and valid in the court. So that is the part of mediation. Online filing and the e-court part, I think I've covered the most of the portions which were there in the fact that of the family court law and the history very briefly I've mentioned. Most important thing I wanted to discuss also is very quickly in a minute I will discuss. I'm also having a watch at the time, which is the challenges and the reforms which is faced by the courts these days. We have the biggest challenge in this country is about the backlog. The backlog is so much that the court hearings come after 3 to 4 months, and they will have a long wait, long queue over the waiting time for their hearing. So biggest challenge which we face in family court is the backlog. Then we have the resources, which is a constraint even for the courts. Not only for the lawyers, it's a problem. Not only for the litigants, it's an issue. It is also an issue for the judges who are sitting there, and instead of taking 25 or 30 cases in a day, they have to run up to 50 cases, 60, 70 cases in a day. That is quite a lot, which is the challenge which is faced by the judicial system also. So what we need is more and more judges, more and more courts, especially in metro cities. Maybe not in rural areas, but in metro cities, cities like Delhi, cities like Mumbai, we need more courts. We need more judges. I think we need more judges, which can be double of the strength which we're having right now to reduce the backlog. And with this, if we are able to reform more, if we are able to get more digital code, I think with that solution will come. I have read somewhere that in India there are a lot of meetings going on, a lot of discussions are going on for having AI judges. If we will have AI judges, which we have in England, they have AI judges from a very longer period. So if we have something like that in India, which is already in discussion and in process, that if we could have for the basic and common cases, which are minor disputes like 138 disputes or some other cat disputes are there, it can go to AI judges, wherein they can have a staple formula and it can be decided by that automatically. So they want to have a bot system. I mean, that's a whole discussion how India will go through that transition phase if really in 2, 3 years we are getting AI judges. How it can reform, it can transform. Maybe the system goes very well. Maybe there can be more clashes, and maybe there can be more demands, or maybe the decisions are more challenged. We don't know. That's the biggest challenge. So though AI judges is not mentioned in this, because that's a very recent thing I've heard about, that there are many meetings going on with the government and the department to have AI judges. So when we talk about today's time, that is something which we are going to see on the part of the challenges. And then last thing I'll talk about is the enforcement. The enforcement is, once, even if somebody gets an order, especially if somebody is in India, and the enforcement is supposed to happen in America or in England or in Italy or Portugal, the enforcement is the biggest challenge because people are not really able to enforce their orders. If somebody gets a decree that somebody is supposed to get a maintenance, has gotten maintenance order, and the amount has been piled up to, let's say, 10 lakh, 20 lakh rupees, or above a crore rupees, who will really help them in the enforcement? Because courts just feel that we have passed an order in your favor. How the execution will work, especially if somebody is in another country, that is the biggest challenge we are facing. With myself, when I'm taking international matter, there are so many challenges to execute those orders which has been passed in India, which has to be executed in Portugal, which has to be executed in Spain, or maybe UK or any other country, and the amount is huge. We don't know where the person is, and the authorities and the department in India, they are not very helpful. So that is one of the challenge in this era where people are living here and there. There is so much of brain drain in India. People live here, get married here, reside in some other country. What to do with that? So I will end my session with here. If there are any questions about my session or maybe the previous session, you can ask me, or maybe write it up.
Thank you so much, ma'am. Whosoever have any questions can raise your hand or can write your question in the chat box. Mahedi sir, you can unmute yourself.
Yeah, good evening, madam.
Good
Hello.
evening. Yes, good evening.
I think it was a nice, short but nice session. I have one
Thank
or
you.
two doubts in mind. I think you related a Krishna Kapoor case, no?
Yes,
This petition, I think this case is involved in the Delhi High Court.
yes.
Is there any pecuniary kind of jurisdiction also when you go from family court to Delhi High Court for this? Because all matters
They have challenged the case you're talking about is probably the probate case, and
right.
the valuation of the property is such it will go to High Court only because of the different state laws. So if you talk about Punjab and Haryana, there it doesn't work like that. Probate petition can go to district courts also. But if you talk about Delhi state laws, so here the pecuniary jurisdiction is such that it will go to High Court. So they are challenging the will, they are challenging the whole trust system which has been created. That is why it is in High Court, because the district courts do not have power on that.
Which what is the limit for that pecuniary jurisdiction in
Well,
case of Delhi?
it was increased. It was increased to 2 crore rupees. So that is a pecuniary jurisdiction for Delhi High Court.
For probate cases?
Yes, probate cases or any other property also. If there is a cancellation of, let's say, sale deed, and the property is worth 4 crore rupees, it will go to High Court only.
Nice, thanks for that, because I wasn't, that's why I thought of,
Yes, it is a valid question because in different state they have different kind of pecuniary jurisdiction.
and I think the last one you told about this, and the couples are one in India, another in USA now. So
Which
how
one?
this kind of, one is in India, another is in USA after divorce and all.
Yes,
How the
absolutely.
maintenance, how the
Yes.
maintenance actually can be enforced, that is a difficult one.
Yes, that's right. So one of the biggest challenges which I see personally is that this is the biggest challenge in one of my currently recent matter also, where there is a 1.5 crore rupees of execution which is pending in the Delhi courts, and we can't find the person. There is no department, there is no authority who can assist at all, and the girl is hanging around with 3 kids. So despite the fact she got a great order, despite the fact there is an amount which is of 1.5 crore, not of 5-10 lakh rupees, that she can really leave it. We don't know where the person is. We don't know how to execute it. And that is how, if we will have more and more international lawyers, if we will have more and more reformation, we can guide them, we can tell them. So there are too many loopholes. The system is a problem, the department is a problem, the organization is a problem. Also, we have a problem that we don't have lawyers who have such kind of qualification or understanding of international laws also. That if maybe one method is not working, maybe we can take 10th method to get that order executed. For a client, what matters is only their relief. They don't really care you have done what law from where, what is your department saying. For them, ultimately what they want is hamara execute kara do order. We want that money. And for the lawyer, the question is, how should I get it done when there is no method, there is nothing, there is no mechanism. If somebody's got an order 5 years ago and is not able to get that money after 5-6 years ago also, and the courts are also helpless on that, where to find the person, that is sad.
Right. Yeah, you are right. And I think the last one, other people are there.
Sorry, Mahendra sir, sorry for interruption because sir, we are running short of time. So,
Yeah, please.
sorry, sir. Madam, like, is there any provision of attachment of property? Because we are not able to find that person. I'm adding one
So
part
you
in
will
that.
always have to involve the embassy. Yes, there is a provision we can attach the property. Yes, there is a provision that if we have to execute, there's an order passed in India, we have to execute, let's say in England only. So from here, we will take the orders if you involve the embassy, and then further you file an execution there in England courts. And then from help of the embassy, help of the county courts, help of the immigration department, which we call it as a home office. In India, we don't even have a home office. In most of the countries in Australia, New Zealand, or if you talk about USA or UK, we have home office there. Where is the visibility of home office? If you say in Delhi only, we have a home office which is a one room. That's the immigration office. There is nothing there. So if you really want to target somebody, if you want to catch hold of somebody, it is extremely challenging. But if you talk about the question, can we do this? Yes, we can do that.
Yes, couple of questions participant asked, they are not receiving summons, phone, mobile number is incorrect, they are not able to find out. So those questions were there by the participants.
Okay.
Sorry to interrupt, ma'am. Just can I say something? It was a
Yes.
very great session, and to hear from you, thank you so much. And thank you, the team, for organizing such a wonderful lecture. And another thing, ma'am, it would be very kind of you if you could be able to share the PPT slide with us or the PDF with us, which you have gone through while the session, because we were unable to see it due to some network errors. So
Sure.
if you could just help us.
I think the Sambhav initiative, they have my PPT, and I'm sure they will be able to share with you.
Thank you.
Yes,
Thank
yes,
you so much.
ma'am. We have shared in the group. Madam, please go through it. I think we can end, ma'am. Sorry for taking so much time. It's already 8. I think 8:30. So, on behalf of organized committee, we are grateful for you, madam, for a wonderful session. I would say, and practical part, definitely. As a teacher, we are very difficult because let me tell you, I did law almost 2 decades back. I failed in family law in second year, so it's very difficult to understand integrity of family laws because so many things are there. Family, we know we have two papers, family law one and two. Even if put four paper, it will be difficult to understand entire things because so
Yeah.
many things, especially last 2 3 years, I would say so many things are coming, especially maintenance things should be granted or
Yes.
not, and live in
Yes.
relationship, illegitimate child, this and that. So it's very, I would say, dynamic things are happening in family court area. So once again, ma'am, for your very wonderful time, and look forward to see you in future sessions also. Thank you very much.
Sure. Thank you so
Yeah.
much. Thank you all for listening out to me. Thank you so much. All the
Thank
best.
you.